Hi, I'm Rick Gordon-Brown, a partner and patent attorney at EIP. EIP is an award-winning IP law firm specialising in patents. We have offices in the US and Europe and a global client base ranging from SMEs to blue-chip multinationals. This short video outlines what small businesses need to know about IP, and patents in particular, and how we at EIP can help. Intellectual property, or IP, refers to creations of the mind, such as inventions, industrial designs, artistic works, or logos used in commerce. Every business generates IP, and it's often a key asset. IP rights give owners of IP control over how their IP is used. Some IP rights, like copyright, arise automatically and without cost, but they can only be used to stop other people from directly copying a creation. Other IP rights, like patents, have to be applied for and registered by a government body in the territory or territories of interest. However, they are generally more powerful than automatic rights because they give a complete monopoly on the creation for a certain period of time. In other words, no one's allowed to use the creation without the owner's permission, even if they later came up with the same idea independently. As a result, these registered rights can be used to significant commercial advantage. At EIP, we specialise in patents or patents, which are monopoly rights that protect inventions. An invention is a solution to a technological problem in any area of industry. It could relate to a product, such as a physical item or a software product, or to a process, such as a new method of manufacture or a way of processing data. The point of the patent system is to publicise details of inventions for the benefit of industry and society as a whole. So the deal is that the government grants you a time-limited monopoly in return for you giving full details of your invention in the patent application, which is then published 18 months after the filing date. So, what can patents do for businesses? First, they can protect market share. Investment in R&D should lead to improved products, but once you launch those products onto the open market, there's a risk that competitors will adopt your innovation and try and free ride on your success without incurring the same level of investment. Patents can mitigate that risk, and our team of attorneys and litigators can help you to obtain them and to enforce them. Patents can help attract investment. Generally speaking, banks and investors will see it as a safer bet, backing a company that has reduced risks and tried to protect its market share. Well-protected IP also demonstrates that you have value in your business and shows proactive and astute management. Patents can also be a negotiation tool. If your product is drawing customers away from competitors, they might look to use their IP rights to try and block your way. Having patents that cover your product, and particularly the features that have caused customers to switch, gives you a negotiating position that otherwise you wouldn't have had. It might even be possible to agree with a competitor to use their technology through cross-licensing. Patents can also be used to generate income, and there's a range of ways in which this can be done. One is to give other companies licenses to use your patented technology in return for payment of license fees, which can be very lucrative. Alternatively, as patents are property, they can be sold. Patents can also be used to cut your tax bill. In certain circumstances, companies can benefit from a reduced 10% corporate tax rate in the UK through use of the Patent Box scheme. Patents also create an innovative image, demonstrating that you are at the forefront of technology. Customers are attracted by this and might be willing to pay more for it. So, what are the key considerations for small businesses, and how can EIP help? First and foremost, get advice early. All companies should engage with IP protection and seek advice at the earliest opportunity. Patent protection might not be the first thing you think about when starting a company, but this can be a critical time to protect the innovations that set you apart from your competitors. Choose your advisor carefully. It's important to speak to a patent attorney who really understands your technology and has good commercial acumen. All of our attorneys at EIP have strong backgrounds in science and engineering, ranging from mechanical engineering, physics and IT, through to chemistry, materials and life sciences. Many have also worked in industry, so have first-hand experience of commercial realities. You should also develop a patent strategy. This should set out how the company will aim to benefit from seeking patent protection for its own technical innovations, and how the company will look to manage risks posed by IP rights owned by third parties. Many of our attorneys are recognised expert IP strategists who are well placed to help you get this right from the start. Put in place a suitable IP budget. Patents can be expensive to obtain. Budget too little and you could end up with inadequate or no protection at all. However, the monopoly they provide usually lasts for up to 20 years, during which they can be highly valuable. We can provide cost estimates based on our experience to help you draw up a budget. Keep it confidential. Generally speaking, you can't get valid patent protection if the invention was made public before the patent application was filed. If you need to discuss your invention before filing a patent application, make sure you have robust confidentiality arrangements in place. We can help you prepare a non-disclosure agreement, or NDA, to be signed by all relevant parties before discussions take place. Agree ownership. Many startups work with external consultants. Without an agreement to the contrary, they might own the IP they create for you. We can draw up agreements that transfer ownership of IP to your company so that it's established at the time of engaging external parties who will own what, to avoid potential problems down the line. Keep an eye on competitors. As patent applications are published, there's a wealth of information out there. We've developed our own software that can be used to identify and analyse your competitors' patent portfolios. If a competitor is investing in R&D and filing patent applications, you can see the technology they're working on and get a heads up of products they might be about to launch. More importantly, if someone has a patent application or granted patent that covers a certain innovation, it could create difficulties for you if you want to use that innovation in your products. If such a risk is identified, our highly experienced team of attorneys and specialist litigators can advise on the options available. I hope you found this video useful and thought-provoking. For more information, please visit our website, eip.com, where you can download a free guide to patents for SMEs.